opening session for just a fantastic day on the good, the bad, and the ugly. We started out with discussing the ugly with David Kaye, who talked about his experience as a law professor in constitutional law, comparative scholar in Hong Kong, and the changes to his life in Hong Kong as part of the national security law. And then we talked about, went from a range of issues related to government surveillance of dissidents to corporate surveillance of consumers and all the sort of risks and rewards and motives related to that. And then finally, the last panel we had was on the good, which are all the efforts that various corporations and nonprofits are taking to try to maximize protections for privacy and the sort of changing landscape with respect to privacy protections as a result of new laws and regulations, and just simply corporate decision-making to make sure that there's a greater enhancement with respect to privacy. So our last speaker, our keynote speaker, an old friend of mine, a good friend of mine, David Kaye. He's a professor at University of California, Irvine, and has had a very, very interesting background and career. But first and foremost, for our purposes, he is the former United Nations Special Rapporteur on the promotion and protection of freedom of speech. So he had that role from 2014 to 2019, traveling the world, literally speaking out on behalf of the United Nations with respect to concerns about freedom of speech. He wrote a book, Speech Police, The Global Struggle to Govern the Internet, published in 2019. He has a very background that I won't go into. I'd rather him speak rather than me. He's a graduate of Berkeley Law School and also Berkeley undergrad. David, we're just so thrilled that you're with us. Thank you so much for speaking. And please just give us your thoughts on surveillance in the context of speech.
Yeah, Roger, thank you so much for having me, and thanks to your team and your students at Notre Dame for putting together really a remarkable day. I'm really honored to kind of be the wrap up, so to speak. So I thought what I would do is spend maybe 15 to 20 minutes, no more than that. I mean, really pull the drapes down on me if I go over that, Roger. Okay. I want to just talk a little bit about the intersection of surveillance and freedom of expression and other international human rights, other rights that are protected by international human rights law. And so what I'll do is basically divide this up into three different sections. So first I'll start with, what are those rights? When we talk about rights that might be interfered with by surveillance, regardless of whether we're talking about mass surveillance or targeted surveillance, what are those rights, at least as a matter of international human rights law? Then I'll talk a little bit about the distinction between mass surveillance and targeted surveillance. So the kind of mass surveillance that we imagine that I think David Law must have talked about at the beginning in talking about China, or the disclosures of Edward Snowden, or targeted surveillance when we're talking about, the kind of surveillance that we've seen of journalists and others in Mexico, Saudi Arabia, United Arab Emirates, and many other places. And then I'll kind of close with a couple of reflections on really one of the hardest problems of surveillance, which is the fact that so much of the surveillance problem is driven by private actors. And how do we think about law that has been designed to govern states as applicable to private actors? So I'll try to do all that in just a few minutes. So let me start with the rights that are implicated by surveillance. Now, of course, when we think about human rights, let me just start with the baseline. I'm talking about mainly the International Covenant on Civil and Political Rights, the ICCPR, which is a really useful place, certainly for us as either faculty or students at an American law school to start, because the United States ratified the ICCPR in 1992, submitted by President George H.W. Bush, and ratification was approved by a Democratic Senate. So what does the ICCPR provide? Provides a few things. Among them include the right to privacy, the right to freedom of opinion, and the right to freedom of expression. And I want to focus on those rights, even though when we think about surveillance, we could imagine a whole range of other rights that are implicated: rights to association, rights to personal autonomy, to due process, and so forth. But let me just limit myself to those three areas. So first, right to privacy. Article 17 of the ICCPR protects everyone's right not to be subject to an interference with her or his privacy that is arbitrary or unlawful. So what does that mean? Arbitrary. That means that any kind of privacy interference should be proportionate and necessary given the both the impact on individuals, the impact on a group, and also the purpose that surveillance or any other privacy interference might involve. What does unlawful mean in that context? Well, that means that any kind of interference with one's privacy must be subject to rule of law standards. And that's been interpreted by human rights institutions, human rights mechanisms, both at the international level and the regional level worldwide, as involving some basic things that we as Americans might think of as due process, right? We might think of that as privacy interference or surveillance that has been provided for by law, that's been provided by clear law. So that is, in other words, law that just doesn't give to the executive branch excessive discretion to do surveillance or any other kind of privacy interference however it wants, but it's governed by law and also has some kind of constraint on it that may be involving the courts. Okay, so that's one set, right? The right to privacy and the right not to be subject to unlawful and arbitrary interference with one's privacy. We'll get into how surveillance might interfere with privacy, but I'm guessing that after a day like you've had today, you can guess what those interferences look like. We don't have to spend too much time on them. What about right to opinion? Well, Article 19, paragraph 1 of the ICCPR protects everyone's right to maintain opinions without interference. And it's actually an absolute right in the sense that it's not a right that's subject to any kind of restriction, which is different from expression, which I'll get to in a minute. So the right to opinion, typically, historically, even maybe conceptually, we would think of opinion as something that we keep in our head, right? Like thoughts, which are, and belief and conscience, religious conscience, which is protected under Article 18 of the ICCPR. Well, in a digital age, I think it's easier to start thinking about opinion as not just what's in our head, right? So that we can imagine saying that the state can't brainwash us, or, for example, because of your membership in a particularly disfavored political organization, putting aside criminal kinds of organizations, but a disfavored organization, you might be subject to detention of some sort, right? That's a kind of interference with opinion, like disconnected from expression itself. Well, in a digital age, how do we hold our opinions? What is an opinion? It might be that you write down notes to yourself and maybe you email them to yourself. Maybe you store them on the cloud. Maybe you have a notebook, a digital notebook that you store. Maybe it's a digital notebook that you use your iPad or some other device with, and that's where you're storing things. In the old days, we would think about that as, a diary, that you're not expressing yourself to the public, but you're holding your opinions in a particular place. Well, in a digital age, surveillance actually interferes with that in a very direct way. And to give an example of one of the ways in which this has come up as a matter of law is attacks on encryption and digital security, right? When you think about the phone, whether you have an Android or an iPhone or something else, and you think about the kind of security that you want to have on that phone, part of that is to protect your privacy and also maybe to protect your opinion, which might be evidenced by what you've written there, or perhaps your browsing history or something else. Okay, last but not least in terms of rights, right to freedom of expression. Protected under Article 19.2 of the ICCPR, everyone has the right to seek, receive, and impart information and ideas of all kinds, regardless of frontiers and through any media. It's very interesting and I think a powerful statement of free speech. And if you think about the difference between that and the First Amendment in the United States, it's very telling, I think, right? The First Amendment in the US Constitution provides that Congress shall make no law abridging freedom of the press or freedom of speech, right? That's interesting, right? Because what it's suggesting is the Constitution is directly geared towards limiting state behavior. But what the ICCPR does is kind of flip it around in a way, because what it says is everyone shall enjoy certain rights. It spells out what those rights are: the right to seek and receive information, which in a digital age maybe involves browsing and downloading material online. And it protects the right to impart information, right? Which could be a post, a tweet, a like online. So it also protects two other elements that I think are useful to mention. One, it protects the right to freedom of expression regardless of frontiers. So unlike most other principles of human rights law, this is a transnational right in many respects, right? Because it protects my right to get information beyond my borders. And it also protects the right of anybody else to get information from me wherever they are in the world. And it's through any media, right? So Article 19.2 of the ICCPR almost seems to have been drafted for the digital age, and not only for the digital age, but for kind of the changing nature of communication, which obviously changes and has changed over the last 100 years in really revolutionary ways, whether it's from radio and broadcast to today's use of the internet. So those are the rights involved. Let's move to the second part, which is what are the different types of surveillance that might interfere with those? Now, before I do that, I should also emphasize that whereas opinion is not subject to any interference under human rights law, expression may be restricted. And that's in Article 19, paragraph 3 of the ICCPR. And that provides that as long as the limitation meets a pretty strict test, a three-part test that involves the lawfulness, so meaning provided by law, similar to the way I was describing privacy, rule of law standards, but also any restriction on speech must be necessary and proportionate in order to meet a specified legitimate objective. Okay, so let's think of two different ways in which surveillance has come up in the last 10 years. You know, clearly speaking about digital surveillance. One thing that's interesting as we think about this is human rights law does not say that surveillance per se is illegal. It might be lawful. The question is whether the mechanisms of surveillance in a digital age, one, are capable of being restricted in such a way that they meet with human rights law standards. And I think there's a lot of legitimate doubt over that. But the other question is, can we imagine what those restrictions might be? Are there legitimate ones? And the two different areas where this comes up would be mass surveillance and targeted surveillance. So mass surveillance, which could be the kind of surveillance that you might have heard of at the very beginning of this symposium, the kind of surveillance we see in China, where there's a camera on every street corner, where there's very intense surveillance, particularly in areas like Hong Kong now, in Xinjiang, in the far west for the Uyghur community, the Uyghur population. That's a mass surveillance that is a form of government collecting massive amounts of data and then afterwards filtering it, using that as a database, essentially, as big data, in order to evaluate what's happening in the population. It might thereafter be a tool to target specific people, and you can imagine that happening very directly if you think about tools like facial recognition or affect recognition that are imposed on top of that mass surveillance in order to determine patterns of what the government might think would be either criminal behavior or, which could be very problematic in a place like China, behavior that is inconsistent with, let's say, the party line, or with what they might describe in very broad terms as harmony in society. Another kind of mass surveillance was that was disclosed by Edward Snowden in 2013, which is the kind of surveillance that involved the National Security Agency and many other of America's allies in essentially sweeping up massive amounts of data from telephony, that is from our telephone calls, from internet data and elsewhere, and then using that as a basis to determine, again, patterns and also individuals who might be subject to national security controls or other kinds of controls. In both of those cases, those are very significant violations, or at least interferences, because it's certainly up to the state to argue, right, to demonstrate that these are ruled by law, by necessity and proportionality and so forth. But on their face, these clearly look like massive attempts to collect data that interferes with individual privacy and the privacy of communities. And that's mainly because these are rules that are largely not subject to the sunlight of oversight or to the kind of judicial warrants that we imagine with other forms of either surveillance or collection of data, if you think in terms of something like the Fourth Amendment in the United States. Okay, so we've got mass surveillance and we've got targeted surveillance. And in that targeted surveillance space, one of the things we've seen over the last several years is an increase in the tools that are available for purchase by governments that otherwise may not have the resources to produce these themselves. They purchase these resources, and these resources are basically malware or software that the state is then given the ability to infect a dissident or a reporter or an opposition politician's device, digital device, and basically track everything that that person is doing. Her location, her contacts, her communications with others, and so forth. That kind of targeted surveillance we've seen really explode over the last 5 or 6 years. We've seen it in the context of Mexico, which had a very massive scandal in which the government and local actors across the country, local authorities, the police and the military, actually were using these tools of malware in order to get at the information held on the personal devices of journalists, opposition figures, lawyers, even some UN officials. We see this also in the context of Saudi Arabia and across the Arabian Gulf in terms of the use of targeted surveillance technologies. And this raises the third issue on which I want to close on to kind of wrap us up. So everything I've described so far, right, the surveillance by the state, the international human rights law that is relevant in this context, this is all about the law that applies on its face to the state, right? States negotiate human rights treaties, they develop those treaties, and then they use them as a tool both to constrain each other, and it's really a tool of political discourse. If you go to, for example, the Human Rights Council, which is starting its next session next week, part of the discussion undoubtedly will involve state obligations to take a restrained approach to surveillance. Now, the question that arises with targeted surveillance in particular is, what do we do about all of these companies that have significant power to collect information and essentially to share their malware, to share their spyware with governments, and not only to sell that to governments, because what happens is a company like the NSO Group in Israel doesn't merely sell the technology to a company and then kind of wipe its hands clean of it. They also operate the technology often on behalf of the government, or in parallel with, or in collaboration, or to support the government. Do those companies have any obligations? Now, that's a difficult question for us, in part because, as I said, human rights law applies to the state, not to these private actors. Essentially, right now, the private surveillance industry is a lawless industry. And it's a lawless industry for a number of reasons. One is that there's almost no significant export control on this technology. And so it is up to the company itself to determine when it can, when it should, when it shouldn't engage with a client, a state. And one of the things that we've seen over the last several years is that the companies are engaging with states that we would all probably agree engage in systematic and consistent repressive behavior. Should there be any obligations on the company as they make those kinds of arrangements, as they develop those kinds of client relationships with governments around the world? Or should we say this is just up to the governments themselves to take this technology and use it in a responsible way consistent with their human rights obligations? Well, there's actually something out there that gives us a little bit of scope for thinking about this more clearly, and it's the UN Guiding Principles on Business and Human Rights. So the UN Guiding Principles, which were adopted in 2012, are a set of principles that basically say, when it comes to private business, right, large corporate actors have an impact on human rights, and they have a responsibility, if not an obligation, to respect the rights of their users and also to respect the rights of those that might be implicated by the tool that they're selling or the business that they're running. So you could think of this in the context in which it first arose, which was back 20, 25 years ago in the context of conflict diamonds, when there were many, many companies that were involved in the diamond industry in Central and West Africa, and their business was helping to fuel conflict. And yet they were not subject to any particular state's jurisdiction when it came to that kind of behavior, or they were subject to jurisdiction of a state that was eager to capture them and to allow them to do that work as long as they got a little bit of payback from it. All of this is very similar to the private surveillance industry, where if they are not subject to export controls, and the export controls internationally are extremely weak, then they're actually working in a kind of jurisdiction-free environment. And that's a problem, right? It's a problem for international law. It's a problem for human rights law. It's also a problem for governance, and it's a problem for those individuals who are going to be subject to these tools. And so as we think about this, and I'll close on this point, I think this is one of the big challenges that we face when we're talking about surveillance around the world. The matter of law, when it applies to states, is fairly clear. From a normative perspective, I think we can all sit down and come up with, these are the principles that bind states when it comes to surveillance practices. But there's very little out there that helps shape what the responsibilities, or even if we took it a step further, move towards obligations of companies. And that's very hard to think through, because we think of international laws binding states and requiring states as the locus for any kind of criminalization or the imposition of responsibility on those private actors. I think if we're looking forward, I think that's where there will be a lot of action over the next several years in the context of, given, and this obviously goes not only to the surveillance industry, it goes to social media, it goes to major infrastructure organizations and companies like Huawei in China and many others. What responsibilities do they owe under international human rights law? There's a lot of thinking going on about this in international human rights law. Some of it is focused on the question of whether it's possible to place this under treaty law. Some of it is under the question of whether there are norms that can be developed that, as a matter of self-regulation, the companies adapt to and adopt over time. With that, I think I'll close and thank everybody for your time, and thanks to Roger and your students again for inviting me. But I'm happy to talk a little bit about this stuff as well.
Great, yeah, if you don't mind, we can take just a couple questions, 2 or 3 questions, that'd be fantastic. Thank you so much for that sort of global panoramic perspective on the issues related to surveillance and free speech. Can you speak briefly about what your life was like as a UN Special Rapporteur for the United Nations, and especially, you know, that's a long period of time from 2014 to 2020 to be doing that job, and just sort of what were your impressions about sort of where you were when you started, and where we were in 2020. I mean, my impression is a lot of these concerns are much greater now than they were when you started in 2014, especially on the private industry side, you know, and the issues of companies basically engaging in surveillance and harming protections of speech, but on the other hand, maybe not doing a good enough job of actually, you know, editing out the bad speech. Can you sort of just give a panoramic view of what was it like in the early years compared to what it was like in the 2020 when you finished?
Yeah.
It's just a remarkable amount of time.
Yeah, it's a great question. And, you know, it's in many respects, it's been a pivotal time, right? So if we think about what was going on in 2014 in terms of the surveillance debate, it was almost entirely focused on the Snowden revelation still, right? The global discussion, you know, sort of pivoted around or centered on the question of, you know, basically the Five Eyes countries, that is the United States, the UK, New Zealand, Australia, and Canada, right? Which are countries that collaborate, yeah, as an alliance on intelligence operations. The big question was, are they using their technological prowess to interfere with, you know, the privacy and the freedom of expression of people around the world? And what does this mean for global privacy? And, you know, many governments were really, you know, to use I guess a contemporary word, triggered by that, right? So Angela Merkel and many other leaders come from environments, and this is particularly true of Germany, come from particular environments where the history of surveillance is a very big political issue. And you can understand why it would be for Germany, given the Cold War experience of just pervasive surveillance in the East. So the focus early on was really, and when I started, was what do we do about mass surveillance? And in fact, my first report to the Human Rights Council focused on encryption and anonymity, which, you know, were seen as tools, I think are still seen as tools to deal with the kind of pervasive mass surveillance that was out there, right? You know, sort of you know, what are the tools that we as individuals have to protect our privacy? Well, you know, we get an iPhone or an Android that has really good privacy protection, or we use a firewall on our computer to ensure that everything is encrypted when you shut it down. I hope everybody does that. Or, you know, you use anonymity as a tool to, maybe you're in a repressive environment, in order to learn about, you know, opposition politics, or maybe it's sexuality or something else that is disfavored as a subject. So that was the situation in 2014. You know, fast forward to 2018, 2019, you know, what happened in late 2018 was the murder of Jamal Khashoggi. And, you know, Jamal Khashoggi was a well-known Saudi journalist. He was at that point essentially a dissident, writing for the Washington Post, and the government of Saudi Arabia murdered him in the Saudi consulate in Istanbul, as is, you know, pretty well known and famous right now. Leading up to his murder, there's almost no question that he was surveilled, not just by sort of the physical surveillance, you know, that you imagine somebody in an unmarked car across the street from your apartment building, but the kind of surveillance of actually getting into his phone, or getting into the phone or the computers of his contacts or others that he was interacting with. And, you know, that turned, I think that woke some people up to the fact, even though it had started before, but it became kind of a cause célèbre in a way, it woke people up to the fact that, you know, mass surveillance is a real problem, but so is targeted surveillance, and we need to figure out how to restrain it. And that was, like, just from the 6 years, I think a major change. In some respects, there's very little discussion these days of the mass surveillance problem, which still exists. And I think that's probably, we probably have to go back to a little bit of a course correction on that as well. But that's, as far as subject matters, I think that was one of the biggest things that I saw change.
So on the technology side, I've noticed just an intense debate about the power of social media, Twitter, Facebook, Instagram, Google, the various ones, to basically be the platform for speech, right? And the struggle that they're all having in monitoring really bad speech, speech that offends their terms and conditions, and yet also wanting to say that we should allow controversial speech, and I agree with you. It has to be viewed differently than the government context, and yet part of the problem, isn't it? Is that it's just simply just a massive crush of information, just like a complete overload of information. And how in the world do they do an effective job to? And obviously they use algorithms, we know that, but how do they do an effective job to protect speech, but also sort of monitor bad speech and get rid of it? I mean, to me, that just seems like an overwhelming problem. And there's lots of issues related to that, but I'd love your thoughts on that.
Well, I mean, one way to think of it is, first of all, that's exactly right, everything you said. One way to think of it is that these companies are engaged in their own kind of surveillance. They really are, and I don't say that as if just to be like yet another person who's critical of big tech. I mean, it is part of it's a factual statement to say that their business model rests on collecting information, essentially surveilling what it is that we're interested in, where we are, who we connect with, what we post, so that they can better package us as accounts, let's say, to advertisers. So they're very much involved in that kind of surveillance economy, which is different than national security surveillance or the kind of surveillance of targeting that we see used by repressive countries, but it's still a kind of surveillance. And the question in that raises is, they want us to be posting. They want us to be online, and they collect massive amounts of content from us. And some of that content is going to involve, hate speech, or it's going to involve threats, which could be terrorist threats, or they could be misogynistic threats. They could be stalking. I mean, there's all sorts of stuff now that involves, online behavior. And the companies are collecting it, they're allowing it to be posted. And the question really is, I mean, there's many questions, as you said, that this raises, but the question is, what standards should they be using to determine what's legitimate and what's not in terms of the kind of information people are sharing? Should they be drawing just from their terms of service? And so it should just be like, what's good for us in terms of, what our advertisers like? Or should there be another standard drawn from, maybe it's human rights law, kind of global standards, given the fact that these are global companies, so that their standards actually are intelligible to people around the world? I mean, it's a major question. I think the very big question is whether they are too big to be able to do this. I think certainly Facebook and Google or YouTube, which are the largest by far in terms of, certainly in terms of the American companies, the big question is whether they, given the fact that it's totally in their interest right now to be everywhere in the world, whether they're doing enough to enforce their rules everywhere they operate. And if you think about all the information that they're collecting and all the money they're making from it, I think there's good reason to doubt that they're doing all they should and can do worldwide to, make sure that their platforms are not platforms for hate, for incitement to violence, even incitement to genocide. I think this is the real big problem of the day when it comes to social media.
Yeah, and sort of the flip side of the problem is something that David Law raised in the context of Hong Kong. And a student sort of asked this question. I'll sort of try to summarize the question. And that is, there are some countries, some jurisdictions where the knowledge of surveillance is so common among the populace that the mere fact that they simply know or assume that the government is monitoring them, that they're self-censoring, right? And David Law said that, he's in a very unique position because he has a US passport. He's a law professor. He has a job back in the United States. He leans in and he completely is unafraid and truly fearless in terms of what he says in Hong Kong. But he says a lot of friends of his and colleagues don't have that same freedom, and they're self-censoring all the time. I'm sure you've traveled to China many times. I've traveled to China many times. You definitely get this pervasive sense of self-censorship in the social credit system and all the concerns about what you say and do. So that's the flip side issue. It's not the wild, wild west. It's the opposite. It's this pervasive sense of we are watching you. Can you speak to that issue? And is that really a common issue, or is that just limited to a few countries? And what are your thoughts about that problem?
It's a really great question, and I think it's a real problem, but it's, as with everything, it's kind of a sliding scale of where that happens. So in a place like China, or in many parts of the Middle East and North Africa, for example, people, I think, are in that space of just believing that they're under surveillance, that their moves are being watched, that when they go outside, they're being tracked, that their contacts are being taken note of, and all of that. And that is a huge problem, and that is exactly related, even though on the face of it or on the surface, it's a privacy interference. We obviously can tell, and the way you pose the question is exactly right. It's also a tool of limiting our expression because we self-censor in that kind of environment. But, I also wonder whether it's just as bad in those countries that are, at least from the self-censorship side, in those countries that are maybe more in the middle, right? Because when the people have less certainty about whether they're being surveilled, they're nonetheless probably going to kind of shape their behavior in the event that they are being surveilled. And this is really one of the big problems of even mass surveillance in democratic societies, because people are going to be careful in a way that maybe they shouldn't be careful, or they'll be constrained in a way that they shouldn't be constrained because of the mere threat, the possibility that what they're saying is being monitored or will be used. Maybe it's not under active monitoring in the sense of targeted private surveillance, but the government may be collecting it, storing it, and keeping it for future use. And that's frightening, right? And it's frightening because and this is, I think, the important point that we can now relate to in the United States in a way that maybe we couldn't to 4 or 5 years ago, which is we don't know what the next government is going to be like, right? So we always have hope in the United States because I think there's a kind of optimistic quality we have that, government will always, I'm not sure even saying this, it makes me, laugh a little bit because there's no way that people really believe this all the time or in every community in the United States. But there's a kind of sense that people think that, look, if my rights are going to be violated, I at least have the courts to go to verify, to prove my right to kind of get a remedy. And I think people now think differently. They think, well, in a mass surveillance society, even if you're in a democratic society, if something happens and we lose a democratically minded government, what are they going to do with all this information that they've stored? And should I be, frankly, I was in this category over the last several years where from time to time, because I was fairly critical of the last administration, I thought, is there a risk in being too critical? Because, this could be stored and used for later use. It was a passing thing, but I imagine others probably felt that as well.
Right, exactly. Well, I think we've probably gone over time just a little bit. I just want to say how much we appreciate your service to the country, to the world as a UN Special Rapporteur. That's an incredible opportunity, life-changing opportunity for you to do that. And I'm sure that will put you in good stead for the remainder of your career to talk about those issues. And just thank you for your time to spend a Friday afternoon talking about freedom of speech around the world. So just want to say on behalf of Notre Dame and the Journal of International Comparative Law, thank you so much, David.
Great. Thanks, Roger. It was really great to see you.
Yep.
And stay well, stay healthy.
Great. Take care. And I think that closes it for everyone. Thank you, everyone, for joining us for this symposium. We will see you next year, hopefully in person. Thanks very much. Bye.